Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. And in this video, what we will cover is really why do we send a dispute letter to a debt collector that we find on our credit reports. And we'll go over 5 reasons and then a timeline, and then we'll have a couple bonus things. And really, this is designed for our clients, so clients of my firm, Watson Herring. But I thought that this might be useful for lawyers that watch our videos, for people who we do not represent, but there may be something that you can learn from this or get some ideas from, and of course you can adapt it however you want. So anyway, let's get started. So here's the overview. We'll look at what does our dispute letter typically say, and then what about gathering information on the alleged debt? That's one reason why we send a dispute letter. How about getting rid of the debt if the collector's not going to pursue it? And then here's a big one, this one in the middle. See if the debt collector will mark the account as, quote, disputed under the FDCPA, the Fair Debt Collection Practices Act, specifically Section 1692E8. And then we'll look at, with this letter, are there other violations of the law that are happening by this debt collector? We'll talk about a timeline about, okay, you send the letter, what sort of time frame are we talking about? And then we'll have some bonus questions or ideas. So first of all, what does the dispute letter typically say? Well, first of all, we want to make it clear in the letter that we are disputing any debt, all debt that this debt collector claims that you owe. So we don't want to get bogged down in typing up account numbers. What if we transpose the number? Our account number is 1234. What if we put 1324? Well, then they go, well, there is no account 123 or 1324. So the point is, I don't want to mess with that. Just make it very simple. I dispute to you Portfolio Recovery or Amsure or LVNV or whoever the company is. I dispute any debt, all debts that you claim to be collecting on me. And then we say, send me proof. And I have 4 items here. So number 1 is, and almost all of these debts are credit card related. If it's a medical bill, then we alter this. But where's the application for credit? Okay, show me when I applied and what I applied for. Okay. Then number 2, let me see the cardholder agreement. Okay, sometimes this is called the terms and conditions. This is the contract, because this is what will tell us what's the interest rate, what are the late fees, what are the over the limit fees, all these different details that will make up the debt. We need to see the cardholder agreement and any amendment. So starting at day 1 when we took out this account, all the way through to the last amendment that applies. I want to see the contract and all the amendments. Then number 3, this is really critical. We want to see the monthly statements from the last time I had a zero balance. Okay, so let's say I took out the card 10 years ago. And 3 years ago, I got it down to zero balance. Well, I'm not saying they have to give me the monthly statements from 10 years ago, but from when I had a zero balance up to whatever the final statement is, because I want to see all the charges, the payments, the credits, the fees, the expenses, like whatever is going into the math here. What added to the amount I owed, what subtracted from the amount that I owed. And then I want to compare that with that cardholder agreement. Because what if the cardholder agreement says the late fee is $15, but I find that for 2 years they've been charging me $45. Well, that means they're collecting a false balance, right? That's a big problem for them under the FDCPA. And then I want to know what's their authority to collect this debt, because I've never done business with this debt collector, and particularly for the folks that claim to purchase the debt. So we're talking about LVNV, Midland Funding, Midland Credit, Portfolio Recovery, Calvary, Jefferson Capital, those types of guys. Give me the full purchase agreement, because that's what will prove whether or not you really own this debt. And then we have, in the last part of the letter, pretty detailed explanation about, I don't want you calling me. I don't want you calling anyone else. I don't want you calling my work. I'm not allowed to get these kind of calls. I only want you to communicate with me in writing by mail. That is the only convenient method of communication. Now, obviously, if you're our client, we take care of this for you. We want this sent out by certified mail, and we want an exact copy of what we sent. So we don't want to just have a Word document on our computer or Google Docs. We want, here's the actual copy of what I sent, exactly what was put into certified mail. Now, we use a service out of Celebration, Florida, which is Orlando, Florida, to handle all of our certified mail. But you could do it on your own, take it to the post office. You just want a physical copy and a PDF of exactly what you sent. So there's no question about that. Okay, so here's one reason we do this. We want to gather information on this alleged debt. Because look, maybe we owe it. And they send us proof and we go, okay, I owe this debt. This is the right amount. Well, then we can take care of it. Maybe we do not owe the debt. And when they send us the proof, we're like, you got the wrong person. Or again, like I mentioned on the last slide, maybe they're charging me the wrong interest rate, the wrong late fee, the wrong over the limit fee. Well, I'm not going to pay a debt that I do not owe. And so the pattern is we are looking on our credit report and we see XYZ debt collector. We're like, who in the world is XYZ debt collector? Well, rather than just paying money to somebody who we have no idea who they are. And by the way, there are so many scams out there, and these scam artists are getting better. They're getting more sophisticated. You know, it's not the guy that can barely speak English who's saying, I'm with the IRS and send me an iTunes gift card. Okay? I mean, does that still happen? Sure. But these guys are getting more and more sophisticated. And so even though they're on our credit report, and that should mean that they're legitimate, but we are talking about the credit bureaus here who are pretty notorious for having lousy procedures. So to me, it's very reasonable before I stroke a check to somebody or give them access to my checking account, I need to make sure that I really owe this person the money and I really owe the amount that they're saying. So this is very reasonable to go to them and say, hey, who are you? Look, I dispute these debts. Send me proof, and don't be calling my family, my work. Don't even call me. Just send me communication through the mail so I know that you're legitimate. All right. So here's another reason we do it. Sometimes collectors are not interested in pursuing the debt, but they're going to stay on your credit report, and this will get rid of them. So they will, what we call, park the account. And we started suing over this and described it in our lawsuits probably 2007, maybe 2006, at least 2007. I mean, we filed dozens and dozens and dozens of lawsuits against companies saying, hey guys, you're just parking an account on our credit report. You're not updating it, but you know it's wrong and you're leaving it there. So it's kind of like if I just parked an old broken down car in your front yard. Now, I don't demand you pay me any money, right? I'm not sending you letters. I'm not writing you, but you got this broken down car in your front yard. And you're like, hey, John, I want this broken down car taken off my yard. And I go, well, I'll do it if you pay me money. Okay. And then my argument would be, well, I didn't do anything illegal. I mean, you voluntarily paid me money. No, it was really extortion. Okay. And that's what these guys do. So if they get a very strongly worded dispute letter and they either don't have the account anymore or they've decided internally we're not going to collect on it, usually they'll send you a letter that says, hey, please be advised we have closed your account and instructed the credit bureaus to delete it. Great. And if it doesn't get deleted, then you're suing somebody. Or they won't respond at all. They'll just say, hey, we're deleting the credit reporting. Either way is fine as long as the credit reporting gets deleted. So the bottom line is we want these debt collectors to say, look, you need to shut up and go away, or you need to put up the proof. One or the other here. Do something here because that will be good for us. So here, in a lot of ways, is the core of what we're doing. We want to see, will that debt collector mark the account as being disputed? This is what section 1692 EA, and I talk about this a lot on videos because it's such a powerful law under the FDCPA. So here's what it says. Communicating or threatening to communicate to any person, that would include Equifax, Experian, TransUnion, Innovis, SageStream, all these different credit bureaus. So communicating or threatening to communicate to, let's just substitute the word, to any credit bureau, credit information which is known or which should be known to be false. Now they would say, well, we think it's valid. But look at the part in green, including the failure to communicate that a disputed debt is disputed. They must tell the credit bureaus this debt is disputed. If they do not do that, then they violate the law. So here's what we show. Number one, we sent the letter to them. Now, you can do it verbally over the phone. Okay, so and we'll try a link to this video. But I did a video talking about how you do a pay for delete. So you call the company, you say, I dispute this debt, and I would like to talk to you about settling. And then if they won't do a pay for delete, well, remember what you said at the very beginning, you disputed this debt. So then you see if they update. But the point of this video is really doing a dispute letter. So number two, the collector receives the letter by certified mail. If we don't send it by certified mail, then, and we're talking about a company that's willing to break the law, why would we be surprised when they lie? I mean, we go, but surely they got my letter. I wanted to save that $5 or $8 or whatever the certified mail is. I wanted to save that money. Well, but you can never prove that they received the letter because they'll just throw it away when they get it. So my approach in my office is for my clients, we send it by certified mail. And then we need the collector to update the credit report. Now, that's not shown in the law. 1692E8 does not say, and they must update after the dispute. But most courts have said that. I disagree with that, but that's what the courts say the law is. So that's what we'll go with for now. Collector updates credit report, and then the collector does not mark the account as disputed. Now they have violated section 1692E8, which means we can sue them. All right, now we also look for other violations of law. So is the collector blowing up your cell phone with robodial calls or text? Well, we told them, do not contact me. And I didn't put the full letter up, and if you guys are interested in the full letter, let me know in the comments, and either I'll put that on a video or I'll have a way for you to get access to that. But we revoke permission to call us. So this may violate the TCPA, Telephone Consumer Protection Act. So this can be $500 or even $1,500 per call or text. So very powerful. Now, are they calling our neighbors? They're calling our family members to get information on us? Well, we tell them in the letter, I don't want you doing that. You don't need to contact anybody. Okay? You can only communicate with me in writing. Are they calling my work? Well, I told them I'm not allowed to get these kind of calls at work. That violates the FDCPA. Are they calling me after getting my letter? Because remember, I said the only convenient way for you to communicate with me is in writing. Are they lying about the amount of the debt? So they say that I owe $3,000 on my credit report, but what they send me shows I owe $2,800. Well, they're lying. Or they say, well, it's made up of all these late fees, but then we can show the late fees, they're charging too much under the contract or the terms and conditions. Okay, so we're just looking at all these different laws. The TCPA, obviously we're looking at credit reporting, which would be the Fair Credit Reporting Act. We're looking at the FDCPA. We may be looking at the EFTA, Electronic Funds Transfer Act, to see are there violations. So all different things we're looking for. So here's the timeline. They get your letter. Then if you don't have a credit monitoring, like Credit Karma or MyFICO or something like that, you can just pull your reports in about 30 to 45 days after the debt collector receives your letter. Now, obviously, we'll know that because we can see on certified mail exactly when they received the letter. And then we check to see, first of all, has it been updated and is it marked as disputed? Now, if it's updated but not marked as disputed, and we're not talking about a day or two, like if they get my letter on December 1st and December 2nd they update and don't mark it as disputed, I'm not going to sue over one day. But if it's 5 days later, or 10 days later, then there's no excuse. I mean, really, they should do it within 1 day, but let's give them a day or two, okay? But they're 3 days, 5 days, 7 days, 10 days. So they get our letter, and then that time period passes, and they update, and they don't mark it as disputed, then we sue for that. And usually, just within a couple of days of catching them, and there's no excuse for this violation of the law, okay? They know exactly what they're doing. We talk about this in other videos, but the point of what they do is they do not mark it as disputed because under most credit scoring models, a disputed debt does not have any impact on your credit score. Well, that takes away their leverage. And so they don't want to give up their leverage. So they just continue to update and they don't mark it as disputed because 99.9% of people won't do anything about it. They don't know it's illegal. Or they say, well, there's nothing here. And consumer lawyers will go, yeah, I don't want to file that case. There's no value in it. Well, there is value in it. Trust me, the debt collector money pays just fine. And we always insist they delete the account and kill the debt. So it's a very valuable case to us. And so we sue them. They get served a few days after that. Then depending on what type of court we sue them in, they may have 14 days or 30 days to respond. And usually by that point, they're talking to us and they're giving us all these excuses. Oh, this new employee hit F5 instead of F7. And we're very careful about this. And of course, we're going, yeah, we've sued you multiple times for this. It's amazing how you always have the same new employee who makes the same mistake on the keyboard just on my client's accounts. Remarkable, really, how that happens. Okay, so here's a bonus. What if the collector does update with the dispute notification? Well, that means we can't sue under that E8 for failure to mark as being disputed. Now, we look at, say, did they send proof? Are they continuing to collect this amount, but they're collecting the wrong amount? Which means they're doing false credit reporting. So that in and of itself does violate E8, the failure to mark as disputed. Let me just show you this if I can go back. So the first part that's not highlighted is just saying, if you communicate or even threaten to communicate false credit information, you violated section E8. And it just gives us an example. Failure to communicate a disputed debt as disputed. That's just an example. But you could mark it as disputed, but still be collecting the wrong amount. That violates the law. Okay, so we may sue them under that. We may need to follow up with another letter. Hey guys, I asked you to give me the statements from when I was at a zero balance to the final statement. You gave me the last 3 statements. That's not what I asked for. Give me these other statements or get rid of this account. We may need to sue, or maybe there's enough that we're not suing, but we're going to that debt collector, that debt buyer, and saying, I tell you what, you've messed up. Maybe it was a mistake. Maybe, we're being very generous here, maybe you didn't intend to do this. How about we don't sue you and you get this off of our account and you kill this debt? And we give you peace here. So there's lots of possibilities. I don't have everything on the screen because some of this we would talk to you privately if you're our client. But the point is, we want to force that debt collector. Remember what we said in the other slide? Either shut up or put up. Okay, so they've got to do something. Now, what if they just don't update it at all? Remember, this is parking the account. They get our letter, they don't respond, they leave it. So we look on our credit report, and there's some medical bill, debt collection, or credit card debt collection account on there. And I'm recording this on December 16, I think. And there's an account from June. Hasn't been updated since June. It says we owe $573. Well, then we would dispute with the credit reporting agencies, with the bureaus. And we would say to them, hey, this account is showing, it hasn't been updated. Metro 2, which is the industry standard for the credit bureaus and for the furnishers of information to the credit bureaus, including debt collectors, that requires monthly updating, assuming there's a balance. So I've disputed this debt. Here's my letter. Here's the certified mail where they received it. They've not responded. They've not updated my report. They've not shown it's being disputed. Obviously, you can't trust this company. They're violating Metro 2. Why are you guys letting them violate Metro 2 by letting them not update every month? delete this account. So now we're using the Fair Credit Reporting Act, which puts liability on the credit bureaus, and we're using their own industry standards. This is what they put out, that they say, this is what we need to do to comply with the Fair Credit Reporting Act. Okay, well, here's your industry standards. We want to get rid of that account or sue that collector or the credit bureaus, the credit agencies, or both. So I hope that this is helpful to you. Again, the right dispute letter sent can have very good consequences for us, bad consequences for the debt collector, because it's very rare that they will properly mark our account as disputed and send us the proper proof and not violate the FDCPA or some other law. So this is a very important step, and this is what we typically do for any client when we're looking at their credit reports. We go ahead and have the client, and usually we do it from our office, but the point is we work with our clients to send these letters out, and then we see, okay, what's this debt collector going to do? Are they going to be smart and go off of our credit report? Or are they going to be arrogant and refuse to follow the law? And then we hammer them in a lawsuit. So I hope this is helpful and appreciate you guys watching this, and I'll catch you in the next video. Okay, take care. Bye-bye.